Welcome to Newsmax TV. I'm Kathleen Walter. From Virginia's capital city, Republican Attorney General Ken Cuccinelli is making headlines around the Commonwealth and the nation with his stand against the Obama administration on health care and illegal immigration enforcement. Our chief Washington correspondent Ron Kessler traveled the 2 hours south to Cuccinelli's Richmond office for an exclusive Newsmax interview.
This is Ron Kessler for Newsmax TV, and we're here with Ken Cuccinelli, the Virginia Attorney General. Thank you for joining us.
My pleasure.
The issue you're taking on, and where you've been successful so far in the health care issue, getting a judge to go along with letting the lawsuit proceed,
right,
is, of course, chiefly the issue of interstate commerce and whether the government can regulate commerce that doesn't exist, inactivity. But of course the Constitution doesn't cover everything, that's for sure. Plenty of stuff is not enumerated specifically. So why do you think this is worth taking on?
Well, first of all, as the judge noted last week, even if ultimately this law is found constitutional, it goes farther than anything ever has that's been found constitutional under the Commerce Clause. And as you noted in your question, the absolutely unique feature of this is that the Congress and the President are trying to regulate inactivity, doing nothing. A state of repose is the phrase the judge used last week. And that is truly unprecedented. And when we say unprecedented, we mean there's not only is there no legal case addressing this, but no Congress before this one has thought they had this power. Even the King and the Parliament acknowledged they didn't have this power back before the Declaration of Independence. So we've got a federal government that thinks it has powers that the government the colonists rebelled against knew they didn't have. It's quite extraordinary.
You have an engineering degree. You also practiced patent law initially. Richard Cullen, a former Virginia Attorney General and also a former U.S. Attorney in Richmond, told me that he sees you as a first-rate lawyer, but also someone who, given your engineer's mind, weighs all the angles before you wade into something. And it seems on the healthcare lawsuit, you were very focused, and you didn't throw in a lot of extraneous things or a lot of plaintiffs.
We took a rifle shot. We have singled out the individual mandate for two basic reasons. First, Virginia's General Assembly passed its own bill last year called the Virginia Healthcare Freedom Act, really last session. It was the beginning of this calendar year. And that bill protects Virginians from being ordered into an individual mandate. Then, of course, the federal health care bill passed a couple of weeks later in direct conflict with the Virginia law. So one of the reasons we've singled out the individual mandate is I'm protecting a Virginia statute, which is part of my oath of office. But first, I'm protecting the U.S. Constitution because of the overreach, attempting to regulate inactivity that we discussed a moment ago, goes beyond the outer limits of the Constitution. Certainly anything the founders envisioned, but even anything that justices in the New Deal era, where it was massively expanded, envisioned. So we're definitely out in constitutional never land, and those two reasons, defending the Virginia statute and the clear violation in our mind of the individual mandate itself, are why we're focusing our attack there. In the Florida case, there are a lot of other things being addressed that we're not touching.
You waded into the gay rights arena with an effort to reject any sexual orientation as being used for the basis of discrimination complaints among state employees. What do you make of the ruling in San Francisco that
well, for one, it's creative. Certainly, the judge appears to have started with a conclusion and thought, well, what's the best way to protect the ruling I'm going to make? And he thought taking evidence was, when you argue about constitutional questions, typically the type of facts that matter aren't evidentiary, they're historical. And the judge is trying to build sort of a social science case, if you will, for his own perspective. I mean, let's face it, the people of California didn't even adopt his position. Virginia, like California, has a marriage amendment, and we will certainly take whatever steps we need to defend Virginia's marriage amendment so that we can continue to treat marriage with the respect and dignity under our law that it currently has. And we'll have to see how that plays out, but I have a feeling that this is the one that's probably going to go to the Supreme Court.
And you've also taken a position challenging the Justice Department position on the Arizona immigration law. What do you feel is wrong about the judge's ruling in that case in Arizona?
Well, first of all, the most shocking thing about that case is that the federal government felt the need to step in and attack a state in court. The way the federal government fails in the immigration arena is by doing nothing. Mm-hmm. They own the responsibility for determining who's illegal and for deporting them. They are the bottleneck for deportation. And if they didn't like what Arizona was doing, they had it in their power to simply do what they've been doing for decades, and that's drag their feet. Why they felt the need to come in and attack the state's law in the manner they did is really very shocking. In an era when we're already concerned about overreach of federal power, this is an extremely aggressive step by the federal government. Very disappointing. One more disappointment in the string of exercises of federal power. I think that Judge Bolton's ruling, obviously it's preliminary, so we're awaiting a more permanent ruling, but she has enjoined parts of a statute that have nothing to do with the First Amendment, and it is very uncommon to see pre-enforcement injunction in an area outside of the First Amendment where you don't have free expression at issue, or that's the primary one. The prospect that some people will be inconvenienced or will be questioned that the judge raised in her ruling as a basis for enjoining the entire section of the law is really very surprising. I don't think in the long run that will hold up. I will say that the sanctuary cities pieces and the elements dealing with employers still stand. The only one where Arizona was restrained was in the law enforcement area. And so 2/3 of the subject areas they were addressing still stand, which we're very happy with. And in Virginia, the ruling, even if applied in Virginia, wouldn't affect our law enforcement because we don't require our law enforcement to make the inquiries about immigration status, but we clearly do permit them to do it and have reinforced, at least in the public mind, the notion that they can do that. I had a recent opinion on this subject. Didn't break new ground, but it was rather surprising to people in the press and some in local government and state government that our law enforcement officials already have the ability to inquire about immigration status. But they do. That still leads us to the point of the bottleneck, which is the federal government's processing out of those who are deportable.
And speaking of government overreaching, clearly the country is turning against Obama. How much of that do you think is because of his policies and how much is because of his leadership and style, blaming Bush for everything, et cetera?
Yeah, that sort of smacks of desperation more than anything. I would say that President Obama is one of the best campaigners we've ever seen. Campaigns are sales, marketing, and communication. Governing is a whole lot more. And you know, they sold the feelings and values that they and attacks on the prior administration in a very generic form during the campaign. But once you take office, governing requires getting down to the details. And those policies that they have actually pursued are so distasteful to the American people, sort of at a gut level, that they have lost popularity, and for substantive reasons. And I think that's perfectly legitimate. I think it's unfortunate that they weren't pressed harder to lay out specifics of what they intended to do during the campaign. But let's face it, a good chunk of the press, as we saw in the Journo list, scandal was actively attempting to get him elected. They were engaged in campaigning within their news outlets on behalf of the now president, then Senator Obama, and that helped avoid that kind of scrutiny. Well, now we have real policies and we can judge performance on those policies, and it is a very bad grade coming from the American people, and I tend to concur.
And by the way, the press also suppressed the association with Reverend Wright until Obama was already winning in the primaries, and then when it came out, Hillary started pulling ahead. The mosque controversy in New York, you know, on the one hand, it's really unfortunate that moderate Muslims are being tarred with this whole controversy, but on the other hand, what do you make of that?
I find the whole thing to be very unfortunate. I think it is a very poor judgment to advance this effort. I find it very shocking, and obviously it being a New York City and a New York matter, I haven't delved into what the legal considerations are. I've just watched it as an observer like every other American, and I see it as seemingly intentionally aggressive and unfortunate. I don't think that helps with the circumstances in our country or in the world.
Well, thank you very much. We appreciate the time, and obviously much more to come. This is Ron Kessler for Newsmax TV.